Perfect. Okay. Wonderful. Hello, everyone. Good evening. I can see people are going to be arriving as we go, so I will drag out my introduction for hours. No, I won't do that. But just to say hello to everyone as and when they arrive. My name's Aoife Nolan. I co-lead with Shu Shin, the children's rights group here at Doughty Street Chambers. And I'm absolutely delighted to welcome you all here for this evening. And as all of you will know from our regular mail outs and shameless self-promotion, the group brings together barristers from across all practice teams to focus on innovative legal advocacy aimed at securing the rights set out in the UN Convention on the Rights of the Child. And Chambers, of course, has extensive expertise across numerous child rights related areas. We've colleagues have huge experience in bringing groundbreaking and really important litigation to all levels of domestic and international courts around children in a public law context, extradition, immigration, mental health, community care, prison law, trafficking, education, child justice, clinical negligence, and inquests. Okay, so real expertise, extensive experience, and also, very importantly, in a way that's reflected in our choice of speaker this evening, a very strong focus on the international, right? Being aware that the work that's done in the UK forms part of global efforts to push forward children's rights through the use of law. So our annual lecture is the Children's Rights Group's annual event, and those of you who are keen attendees of this may have noticed that, in fact, we are having our 2022 one slightly late for, shall we say, logistical reasons. But we're sure you'll agree that we couldn't have a more outstanding speaker. We are absolutely thrilled to have Ann Skelton with us. Ann is a professor of law, and she holds the very distinguished UNESCO Chair in Education Law at the University of Pretoria. Not content with one leading important academic post, she is also the Chair on Children's Rights in a Sustainable World at the University of Leiden, which is a groundbreaking and very well-known Masters in Children's Rights, which Anne is deeply involved in. She's also a visiting professor at the University of Strathclyde, and she teaches in the Oxford Masters on International Human Rights. So she's all over the place all the time, okay? She has worked as a children's rights lawyer and a child lawyer in South Africa for over 30 years. She established strategic litigation work at the Centre for Child Law, which many of you who do comparative international work will know about, and she's appeared as counsel in numerous landmark cases, including 12 in the South African Constitutional Court, which, as we know, has been a shining light in many different ways when it comes to protecting children's rights at the national level. Her global influence has been recognised by, amongst other things, her receipt of the Juvenile Justice Without Borders Award in 2017 and her involvement as chairperson of the very important advisory board of the UN Global Study on Children Deprived of Their Liberty. But perhaps most importantly, and certainly of great interest to the audience the week after we have the UN Committee on the Rights of the Child's concluding observations on the UK, Anne is chair of that committee and has been since May, having joined that body in 2017. Now, before we get to questions, I should probably mention that because Anne has a British passport, she was not directly involved in those concluding observations. So that perhaps needs to be borne in mind as you slightly angle your questions, perhaps in a more subtle way about the outcome of that process. A couple of housekeeping things. The lecture is recorded. It'll be uploaded afterwards. We're going to have Anne, who's going to speak for about 35-40 minutes, and then we're going to turn to our wonderful expert panel, who I will introduce at that point, and you, of course, have them in your brochure as well. And then we're going to have a Q&A and a discussion. So obviously, we have a certain number in the room, but I can see we already have a very large number online, so hopefully there'll be good scope for exchange and discussion. So Anne, thank you very much.
Good afternoon, colleagues. It really gives me great pleasure to be here with you in London and to have been invited to deliver the annual Children's Rights Lecture at the Doughty Street Chambers is indeed a very great honour. Thank you, Aoife, for that nice introduction. It's wonderful to be amongst professionals and like-minded people who have a passion for children's rights and also the skills to be part of the solution to some of the challenges that are facing children's rights today, here in the UK and indeed globally. I'm going to begin my talk today by painting a picture of the current global situation of children's rights. And I'm going to consider what I call the fallbacks that are happening, due at least in part to the COVID pandemic and related economic downturns. I will then move on to talk about the pushbacks against children's rights that are happening in the Human Rights Council, the General Assembly, where children's status as rights holders is being questioned under a shroud of enthusiasm for cultural diversity, which is actually masking patriarchal attitudes. What we see here is that children's agency and their autonomy, their right to participate, is being reframed by states. They are using Article 5 of the Convention on the Rights of the Child, which I'll explain a little bit more later, which deals with parental guidance, but also deals with evolving capacity. But states are overemphasizing the parental guidance part of this, suggesting that parents have superior rights that can be used to limit children's rights. Civil and political rights are under particular attack, as well as girls' rights and the rights of children of diverse sexual orientation and gender identities. Sexual rights and the concept of bodily autonomy are questioned. At the same time, UN bodies are increasingly talking about youth rights, but somehow children's rights are getting lost in the process of this new enthusiasm for youth participation. It's a difficult conversation because we want more youth participation, but at the same time, not at the expense of children's participation. And so then I will end by at least trying to end on a positive note and think about what can we do. So this year is the 75th anniversary of the Universal Declaration of Human Rights, which was adopted by the UN General Assembly in 1948, just 3 years after the end of the Second World War. And then a declaration on children's rights was adopted in 1959, 11 years after that. But it wasn't until 30 years later in 1989 that the Convention on the Rights of the Child was adopted. And it was very different from the declarations that preceded it because of the fact that it went beyond declaring that children's well-being must be protected and that children should be the beneficiaries of charitable endeavors and so on, and actually reframed all of that as children being holders of human rights. And it perhaps doesn't sound that dramatic now, but at the time it was quite a big advance on the understanding of where children fitted within human rights discourse. So the convention, as we all probably know, was warmly embraced by the international diplomatic community and soon became the most widely ratified treaty in the world. And that in itself is interesting. I wonder if states assumed that children's rights would be easy. I asked this question in part because of something that happened in South Africa when we were drafting the South African Constitution, and there was a proposal for a very comprehensive provision on children's rights in the Constitution, which made it in. At that time, the leader of the opposition, Tony Leon, said he didn't have any objection to children's rights going in because, as he said, children's rights, like chicken soup, could do no harm. I've written elsewhere that in South Africa, children's rights have not been quite the bland pottage that he apparently thought they would be. And with a generous sprinkling of activism and access to justice, have simmered into quite a piquant melange. If the worldwide enthusiasm for ratification of the convention was linked to the chicken soup effect, with a side note here that the United States perhaps doesn't like chicken soup, or knew all along that chicken soup isn't that benign, I think states are now waking up to find out that children's rights are far more spicy than they thought they were. And that is perhaps where we see this beginning of the pushback coming. I'm going to leave the food analogies behind in case you start wanting to get to the reception, or those of you at home go off to the kitchen to get a snack. And I'll move on to some of the benefits we've seen from the Convention on the Rights of the Child, because we've had it now for 30 years, and we really can see that it has catalyzed many significant improvements in the lives of children around the world, with millions having improved access to healthcare, to child protection services, to education. Many constitutions in the world now include children's rights provisions, and almost all countries have done law reform to try and bring their laws and policies in line with the Convention on the Rights of the Child. And of course, many of these improvements that we've seen at the national level were also supported by UN agencies such as UNICEF, who are doing a lot of developmental work alongside this rights framework as well. The recently released 2023 UNICEF annual report provides an overview of the current state of children's rights. It describes what it calls a polycrisis in children's rights, which comes off the back of the COVID pandemic and is also related to economic downturns, as well as factors such as current armed conflicts, resultant displacement of people, and increasing pressures related to climate change. More than 5 million children under the age of 5 died in 2021. This is what the UNICEF report says. More than 5 million children under the age of 5 died in 2021, primarily in low and middle income countries in sub-Saharan Africa and parts of Asia, South Asia. And 54 countries are now no longer on track to meet the Sustainable Development Goals. And this is very concerning because states committed themselves to these Sustainable Development Goals. And in some ways that has often deflected away from a rights-based approach to a more sort of developmental, going back to a developmental approach. But even now the developmental approach looks under threat because many states are admitting they're not going to make it. They're not going to achieve these goals that they set themselves. Immunization coverage continued on a downward trajectory, which of course started in the COVID pandemic, but has continued. And without urgent attention, the related Sustainable Development Goal on immunization will be unattainable. Disruptions to education in 2022 persisted, as did learning losses, disproportionately affecting the most marginalized children, especially girls. In low and middle income countries, the proportion of 10-year-olds who cannot read or understand a simple text has risen to 70%. That's 70% of 10-year-olds in low and middle income countries can't read for meaning. You know, they may be able to read rote, but they don't understand what they're reading. And that's about poor quality education. Because we're talking now about the children who actually can read. I'm not even talking about all the children who are not in school who can't read at all. After declining in recent decades, child marriage and female genital mutilation are now expected to increase. Globally, the births of 1/4 of children under the age of 5 have never been officially recorded. And if your birth is not recorded, the state doesn't plan for you, doesn't provide for you. And often you don't even exist. You can't get health services, you can't get into school. So non-registration of births, which again took a serious dip during the COVID pandemic, has continued to be a problem. And as if all of that was not enough, more than half of all children, according to the UNICEF report, approximately 1 billion children, live at extremely high risk from climate hazards. Recently, the Assistant Secretary General of the UN, Ilse Brans-Keres, stated at a high-level conference on the state of global human rights that at the end of last year, more than 450 million children, or 1 in 6, were living in a conflict zone, the highest number in 20 years. The highest number in 20 years. So that's how we know we're talking about a regression here. a record 36.5 million children were displaced from their homes as a result of conflict, violence, and other crises. The conflict in Ukraine alone has caused 2 million children to flee their country. On that note, as I'm sure you're aware, the International Criminal Court has issued a warrant of arrest for Vladimir Putin and the Child Rights Commissioner, very concerning, Maria Lvova-Belova, for the suspected unlawful transfer from occupied Ukraine to Russia. And Russia's response to this? To put the chief prosecutor of the ICC, Karim Khan, on a wanted list. Child poverty is on the rise in many parts of the world. As of 2022, half of the 1.2 billion people living in multidimensional poverty were children. And this is not only in developed countries. At this point, I'm sure your minds are just glazing over all these millions, and it doesn't make any sense anymore. It's too big for us to comprehend, and it's far away as well. Well, actually, it's not so far away, because during the Committee on the Rights of the Child's recent session in May, the committee reviewed both France and the United Kingdom, and it is striking that both of these highly developed states were asked searching questions about child poverty by committee members. In the concluding observations to France, the committee expressed concern about, and I quote, the situation of an increasing number of children and families living in poverty, who were also worst affected by the COVID-19 pandemic, particularly children and families headed by single parents, children living in shanty towns, that would be in the overseas territories, and living in emergency accommodation for long periods of time. And then, with regard to the United Kingdom, and Aoife has already given my disclaimer in this regard, noting with deep concern the large number of children living in poverty, food insecurity, and homelessness, the committee recommends that the state party develop or strengthen existing policies with clear targets, measurable indicators, and robust monitoring and accountability mechanisms to end child poverty and ensure that all children have an adequate standard of living, including by increasing social benefits to reflect the rising costs of living and abolishing the 2-child limit and benefit cap for social security benefits. So what I've been talking about up until this point is what I would just call the fallbacks in children's rights. It's not a pushback, but it's happening because of a number of events that are occurring in the world, because of COVID, because of economic downturn, because of war, because of climate change, but then also because of a failure of international cooperation, also because of failure of a lack of political will. And so there's a slippage, a regression that we can see. But an equally concerning development is what is being called pushbacks against children's rights. On the global human rights stage, the space for children's rights is shrinking. It is part of a broader context in which there is a contraction of the space for human rights. So it's not only children's rights that are coming under this pressure, but it is part of a broader contraction, and I think we can identify, though, some specific issues that are related to children's rights. This is all a rather sad truth in the year of the 75th anniversary of the UDHR, and indeed, in the recent 52nd session of the Human Rights Council, the Secretary General of the UN, Antonio Guterres, noted that the Universal Declaration of Human Rights was under assault from all sides. The Secretary General warned of the erosion of human rights around the world, and in some cases, of reversed progress in human development. The High Commissioner for Human Rights, speaking at the same event, also said that much of the progress made over decades was being reined back and even reversed. Most conspicuously, he said, for women and girls, the civic space and the freedoms enjoyed at times of peace and through sustainable development are in retreat. He warned that the oppression of the past can return, along with the old authoritarianism, with its brutal limits on freedoms writ large and the suffocating straitjacket of patriarchy. So what's going on? In particular, what's going on with regard to children's rights. The Executive Director of UNICEF, Catherine Russell, recently pointed out that the pushback against children's rights is occurring in intergovernmental fora, including at the General Assembly and the Human Rights Council, and it's happening at the country level as well, with some lawmakers seeking to prioritize parental rights and the interests of the family at the expense of the rights of children and women. We are also seeing efforts to undermine the integrity of international and national standards pertaining to children. So a sense that the Convention on the Rights of the Child is beginning to have its legitimacy questioned. It's being undermined. Children's rights that are perceived as challenging patriarchal structures and gender norms and parental authority are at heightened risk. These include civil and political rights, sexual and reproductive health rights, the right to be protected against domestic violence, and the rights of LGBTQI+ children. In some countries, governments are working to roll back laws, policies, and plans that address domestic and gender-based violence, as well as those that promote gender equality and diversity. These efforts are often accompanied by hate speech, disinformation, threats against human rights defenders, and democratic retreat. So let's drill down into some of these issues in more depth. The issue of children's autonomy is coming under pressure in the Human Rights Council as states debate the wording of resolutions, so that there are a few resolutions annually that are debated in the Human Rights Council that relate to children's rights. And it's really fascinating to look at the wording, how the words are chosen, how they are developed, what gets in, what gets taken out. And traditionally, one saw certain groupings working in certain ways, but as I will demonstrate as we go, there are some interesting bedfellows that are developing around some of these pushbacks on children's rights. It's not the usual standard West versus South or North versus South. It's not quite that anymore. So let's look at Article 5 and what's been happening around the wording of Article 5. So I'll just remind you about Article 5 in case you don't know the Convention on the Rights of the Child off by heart. It says, states parties shall respect the responsibilities, rights, and duties of parents, and it goes on into all alternatives to parents, to provide in a manner consistent with the evolving capacities of the child, appropriate direction and guidance in the exercise by the child of the rights recognized in the present convention. So children's rights advocates tend to focus on the words evolving capacity in Article 5. So for child rights advocates, when we say Article 5 rights, we tend to think evolving capacity. What states are doing is when they look at Article 5, they focus on appropriate direction and guidance. In fact, they focus on direction and guidance. They don't worry too much about the appropriate. And so they are pushing back and using Article 5 as a restrictor on the rights of children. And they are pushing back on anything that suggests that children are separate rights holders and are putting children back into families. So families must decide. This is where it all is going to happen. We'd prefer to have children in families, and then the state can serve families or help families. But what was Article 5 actually aiming to say? The article starts with the words, states parties shall respect the responsibilities, rights, and duties of parents. So while the family was already protected in international law when the Convention on the Rights of the Child came into operation, the CRC, notably through Article 5, brought a new groundbreaking element. Not only was the family protected against undue state interferences, so the state must protect parents' duties, rights, and responsibilities, but also children had both the right to receive appropriate direction and guidance from their parents and to receive direct protection from the state should their rights not be upheld within the family environment. And so in this way, the Convention rendered the child visible as a subject of rights within the family, entitled to protection on their own behalf. It also empowered the state to intervene when necessary to protect the rights of the child, in recognition that the best interests of children are not always protected by parents. So we can look back to the travaux préparatoires of the Convention on the Rights of the Child, which is the go-to to go and see what were they thinking at the time. What was said there was, in protecting the family from the state, the family must not be given arbitrary control over the child. Any protection from the state given to the family must be equally balanced with the protection of the child within the family. That's what Article 5 was supposed to mean. So, read properly, Article 5 affirms that all children have a right to exercise their rights, irrespective of their age, and that's the idea of evolving capacities. All children have rights, no matter how young they are. Babies have rights, but as their capacity evolves, they will take more and more active agency in exercising their rights, and this is where they need appropriate direction and guidance. So children's evolving capacities then are important because as children grow older, their capacities should be respected by their parents and their families, and it should be understood that as they grow older, they must also take a bit more responsibility for their own decision-making and so on. This is how we grow up. In line with its purpose to strike a balance between the rights of the child, the rights and duties of parents, and the duty of the state, and the recognition of children as subjects of rights within the family, Article 5 both establishes and delimits the rights of parents to provide direction and guidance. So parents' right to guide their children is not absolute, but rather delimited by children's status as rights holders. The committee's position then, gleaned from the general comments that have been written on some of these issues in the past, although there isn't a general comment on Article 5, is that any direction and guidance should aim at enabling the child to gradually exercise their rights independently, in keeping with the principle of indivisibility of rights. Interpretation of appropriate direction and guidance must be consistent with the whole convention. For parents to provide appropriate direction and guidance to children in line with the CRC, they must take into account children's views. As a child grows and matures, greater weight must be ascribed to the views of the child, with parents adjusting their guidance and direction to reflect the child's evolving capacities in the exercise of their rights. Please remember this next time you're in a dispute with your children about what they can and can't do. The concept of children's evolving capacities is therefore central to the recognition of children's status as rights holders independently from their parents, and contributes to protecting the child from arbitrary family control. The Committee on the Rights of the Child intends to issue a statement about this, because what we've seen now is that the states either don't understand what Article 5 is all about, or are willfully misunderstanding Article 5. And I think it will be helpful to have some kind of normative statement from the committee that can then be used by progressive states and by advocates for children's rights that are trying to push back on pushbacks. Another concern is it's not only in the Human Rights Council where some of these things are happening, but also the General Assembly, particularly on the issue of gender. And this is nowhere more obvious than in the politicization of adolescents' rights to sexual and reproductive health and rights. There is something called the Omnibus Resolution on the Rights of the Child, which is tabled on an annual basis in both the Human Rights Council and in the third committee of the General Assembly, which deals with human rights. And it is the primary human rights resolution covering the rights of children, reflecting taking the rights of the Convention on the Rights of the Child and putting them into this normative framing. It's important because it's the states that write this document. It's not an expert-written document, it's a state-written document. Of course, they meet with experts and they are lobbied by NGOs and so on in what kind of wording would be put in, but it is a very political process. And if we look back over a few years, we can see that there's been a regression in the language. So in 2015, for example, I don't know what was happening in 2015 that made it like this, but the resolution that year of the Human Rights Council, for example, called on states to include comprehensive evidence-based education on human sexuality in a manner consistent with their evolving capacities. However, in subsequent reiterations of the resolution adopted by the Council, no reference is made to sexual education. It's been taken out. And what we see is that child sexuality education is now being removed from all kinds of places, including documents that deal with violence against children. So that's very concerning because it means that there's a reframing, and it seems to be that states are avoiding the word comprehensive. But instead of just taking out the word comprehensive, they take out comprehensive sexual education. So you don't get any sexual education, then let alone comprehensive. And the word sexuality education is also quite different from the word sexual education. And states aren't having any of that sexuality stuff for children. Progressive states, and there are some, actually they do still win some of these debates. They do still win some of these debates, but it's hard won. And it goes on for hours and days. So they are arguing that the negotiated texts leave out important words, are restrictive, and there's a constant reference to cultural contexts and guidance from parents. NGOs are complaining as well that the language of referring to family is increasingly coming in. So wherever you find children, the states want to add "and families" or children within the family. And there's just basically a shift to away from comprehensive sexuality education to comprehensive education by families. So giving back the responsibility to educate children about sex to their parents. And there's a lot of detail, but I don't think I need to go into it all. But what does worry me a lot is that even the resolutions that draw attention to challenges faced by children, including sexual abuse, exploitation, violence, trafficking, rape, early and forced marriage, to name a few, at one stage there was an understanding that having good education would also be helpful in these situations, and that language is also being taken out. And where we do find access to sexual and reproductive something, it's health services. Access to reproductive health services is still there, but not health and rights, not sexuality education. So, I mean, it may seem a small nuance, but girls do need information on their reproductive health rights. All healthcare services related to pregnancy and maternal health might be there, but they're often too late for girls, and they don't necessarily help them to decide when and with whom to have sex, and when and with whom to have children. It therefore appears that, although acknowledging the challenges faced by girls, the need for states to empower children, including girls, with regards to human rights education is falling back. States don't acknowledge that that's an important part of protection. What's interesting also is that strong alliances have been formed between unlikely states who have the same political positions on gender issues, but on very little else, including the Russian Federation, the United States, the Holy See. Okay, you might have expected to see them there. States within the Organization of Islamic Cooperation, some states within the EU, and many African states. So what we see here are cross-regional coalitions seeking to deny sexuality education, child sexual education, and so on, in a kind of general way. And indeed, some EU states, such as Austria, Hungary, Malta, Italy, Romania, Slovakia, and Poland, have made very emotive statements against sexual and reproductive health rights, thereby revealing the challenges faced by the EU to ensure compliance by member states to adhere to EU ideals. In Africa as well, we see occasionally South Africa breaking away and not going with the rest of Africa because of its own constitution being so progressive. But there have been some notable and embarrassing incidents where South Africa voted with the rest of Africa on issues that are actually already clarified in our own constitution. So look, this is a powerful and dangerous pushback against rights. And with the rise in awareness of rights in sexual identity and politics, it's becoming more intense. And I don't see it. I don't see the pot coming off the boil, going back to those food analogies again. And what we're seeing at the country level is in many countries, there is a deployment of children's rights language to promote conservative agendas. One very recent example is in Uganda, where a new law banning homosexuality has just been passed, and it has life imprisonment for consensual homosexual sex. But if one of the persons is a minor, it's the death penalty. And the arguments used by the Ugandan government are all couched in child protection terms. And it's so complicated because children need to be protected from sex with adults, but there's also adolescents having sex with each other, and that needs to be treated differently from adults having sex with children. So it's a very difficult space to speak about from a children's rights perspective, and it's getting more fraught with difficulty as time goes on. And child rights activists are being trolled on Twitter for even suggesting that adolescents should be allowed to make sexual choices. The Committee on the Rights of the Child holds pre-sessional meetings in which we meet with civil society. So we're often hearing from civil society actors and children themselves, we meet with children as well, telling us about what's happening at the country level for them and how difficult it is. And these meetings are held in private. They're held in private to protect the NGOs and the children from reprisals by the state. That's always been the rule, but I've never really worried about it very much. I never thought that much about it. But now recently, I'm actually starting to realize how important it is that these meetings are private, because if these children were heard to be saying some of the things that they're saying, you know, I think they may be at risk. For example, most recently, we've received submissions from civil society actors from Paraguay, who told us that the government has simply excised the word gender from all government policy documents. This includes any references to gender-based violence. So they made claims that this is happening due to a well-orchestrated and funded conservative lobby group. So I think we have to look very hard to see what's happening here, but we don't have to look very far, because I think it's happening in many parts of the world, and we can see it. It's palpable. I've chosen to focus on these points, but regression in children's rights as part of a broader regression on human rights is also evident in other spheres. Migration springs to mind immediately as an area where there is pushback, and where states, even states that were previously progressive, are shifting their policies. Now, in the interest of time, I won't go into detail about this, but as you all live and work in the UK, I don't think I need to explain it any further. Lately, we have seen an increase in children standing up for their rights through exercising their civil rights to freedom of association and speech, such as girls in Iran fighting the wearing of the hijab and other issues, or even those standing up for the rights of others, children standing up for the rights of others, like children in India fighting for citizenship rights, children in South America fighting for the rights of their teachers to get decent work conditions, and of course, children standing up for the rights of all of us. Think of the way that they've moved themselves to the front of the climate change agenda. And as they do so, they are increasingly meeting pretty harsh feedback from society, from governments, and in some instances, this can be very, very dangerous, as we've seen in the context of Iran. So these are concrete and sobering examples of the shrinking space for children's rights. I'm going to try and be more positive now. In 2022, the UN Secretary General expressed support for the drafting of a UN guidance notes on child rights mainstreaming. And this is a great idea. It's to make sure that a holistic children's rights approach is embedded across the UN system, across all three pillars and in the regions and in the field. However, what we've seen concurrently to the process of drafting this child rights mainstreaming document is that actually the UN Secretary General is focusing far more on youth rights. He's giving a lot of space and there's a lot of budget for the youth rights agenda. And somehow quietly, children's rights mainstreaming is drifting away. So we need to be very vigilant to make sure that that doesn't disappear. And there are some opportunities coming up in which we could try and push that. The Secretary General's Our Common Agenda. And in 2023, there's the Summit of the Future, which is a big UN event. And children's rights activists are gearing up to try and, make important submissions there. So I'm now moving towards the end of my speech, and I want to leave you with some hopeful ideas about what we can do to push back against the pushbacks. Firstly, I think it's important for us to re-engage with the text of the Convention on the Rights of the Child. We need to have more faith in it. I don't like to hear people saying that it's outdated. It's actually stood the test of time. That's what I would say. Of course, like everything, there's normative development, and that's what the general comments are for. Of course, not all states accept that general comments, well, they don't consider them binding. They don't even think that they should be written, some of them. We were told recently by Russia that we should stop writing general comments because we're not supposed to be doing that. But rights can't be static. They do move on, and so having a treaty body interpretation of rights in a contemporary context is, I think, useful. But we shouldn't lose sight of the fact that our biggest tool is the convention itself, because all the states in the world, except the United States of America, have ratified that convention. And we actually need to invest more in time and energy in underscoring the provisions of the convention. As I pointed out to you with my more detailed discussion of Article 5, there's a lot in there that we skim over, that we don't see anymore. And we need to revisit that and really engage with what the convention offers. And then I think, on a more practical note, what we as lawyers, as children's rights activists and advocates, what we can do is that we can ensure that when children's rights are violated, they have access to justice, that they're able to claim their rights and are able to get the required remedies. We can do this at the national level, where the pathways of access to justice should be built. We don't want children to have to go to the United Nations to get their rights sorted. They need to do it here. And if the system is being resistant, we need to keep fighting in the system to build those pathways and to make those pathways. You just got to keep going till you get a judge that will do it. And of course, eventually when that fails, we have to think about taking our fight up to regional bodies and international bodies. And we have a responsibility to make those mechanisms work for children. The Convention on the Rights of the Child has an optional protocol on a communications procedure. 50 states have ratified it, which is not many if you consider that 196 have ratified the convention. But it's a promising start. I'm not expecting that the United Kingdom will be ratifying anytime soon. But remember that the United Kingdom has ratified some of the other treaty body communications procedures and has, of course, the European Court of Human Rights and so on. So there's still a lot that can be done in the regional space and the international space. And then, of course, just 2 days ago, I participated in a seminar marking the end of a project called Advancing Child Rights Strategic Litigation, in which Aoife was the lead researcher. And this project mapped litigation efforts around the globe, and it uncovered a lot of very encouraging and interesting movement lawyering, in a few cases actually led by children and youth, but in all cases brought by serious-minded, committed lawyers working with NGOs. And so the kind of people that we have in the room here are the kind of people that all over the world are trying to use their skills and their knowledge to advance children's rights. So please keep up the good work that you do. Thank you.
Thank you so much for that hugely stimulating talk. Very worrying picture from these threats to children's rights, from aggression to direct full frontal attacks, and this notion of a realignment of opposition and these cross-regional coalitions are very, very concerning. This notion of a shrinking space for children's rights, I think, is something that we'll certainly hear from our respondents as well. I'm going to now rather turn straight to our expert respondents. You have their bios in front of you, so I'm going to keep my introductions short. You will know, many of them you will know already. And I just want to start by turning to Caroline Willow, who is the director at Article 39, in fact, the founder director of Article 39, which is a charity that fights for the rights of children in institutional settings. And it would be wonderful, Caroline, if you could give us your thoughts in response to Anne's speech, and also about the state of affairs of children's rights in the UK at the moment.
Thanks, Aoife. So Article 39, if that isn't in your head already, look that up when you next read the Convention on the Rights of the Child, because that's where it's from. I did also used to work for an organisation which was run by children called Article 12, so maybe by the end of my life I may have gone through all of the different articles. And please forgive me, because I'm going to focus on the pushback on children's rights in care. And then when we get to questions, which I'm sure will focus on your speech, I'll come back to that, if that's okay with you and Aoife. So England's children's care system is not worthy of its name. It's not currently for all children. Even when children have been accepted into the care system, it doesn't provide care to all of those children, and it's not a system unless you accept that a set of processes and arrangements that are driven by crisis and chaos and lack of political will and funding is a system. And because I've only been given 5 minutes and children's rights is my pet subject, I'm going to really try to structure my time, and I've chosen 4 main pieces of evidence to show that the children's care system is not worthy of its name. It's not worthy of children, of course, that's the point. Firstly, we don't have enough homes for children in our care system. We have children that enter the care system and are being delivered hundreds of miles to communities, to neighbourhoods, to areas of the country, even to other countries, to Scotland and Wales from England, to England and Scotland from Wales, because there are no homes in their local areas, which is what should be in place for them if the law, domestic law, let alone the UN Convention on the Rights of the Child, international law, was honoured for them. 44% of children currently in the English care system do not live within their home local authority area, and 21% of children live more than 20 miles from their family home. 20 miles, you might be thinking, that's not much. Well, I grew up in South Shields and Newcastle was 11 miles away, and I can tell you, Newcastle was another country to me when I was growing up. Secondly, an annex has been deliberately created and backed up by law for children who are aged 16 and 17. We have now law and government policy that affirms that children who are in care at age 16 and 17 do not have to receive care. In 2021, through secondary legislation, the law was changed. For the first time, we have age-based planning and decision-making on where children in care live. So for children in care aged 16 and 17, we have new terminology of supported accommodation, which has 4 categories. It includes, quote, self-contained units for those children. It also includes properties that they share or live alongside adults who have their own profound struggles, adults who have come out of prison, who have serious and sustained mental health difficulties, adults who are struggling with addiction. This is now government policy and it's in our law. The supported accommodation, unlike children's homes, will be inspected every 3 years. Children's homes, it's 12 to 15 months. It used to be 6 months. So there's been retrenchment in children's homes inspections, and now for 16 and 17-year-olds, it will be 3 yearly, and it will be provider level. That is, only a selection of where children aged 16 and 17 live will be visited by inspectors. 37% of 16 and 17-year-olds in care currently live in this type of careless accommodation by design. So this hasn't just happened without government knowing. They have introduced secondary legislation and guidance to support it. Tell me how much longer I've got. Have I done my 5 minutes?
Do one more point.
That's just 2 points. Okay, my third point was about profit making and the proliferation of profit making. So there is no legal protection, no safeguards that have been put in place for children who enter the care system, from businesses collapsing, businesses deciding that they want to put their money in their investments elsewhere and close the accommodation. You'll all know, there's lots of lawyers here, you'll all know about Section 21 notices for private renters, that the law is going to change so that landlords cannot just say in 2 months you're out. Well, there's no such protection for children in care. And my fourth main evidence was to talk about the illegal migration bill and the hideousness of that in respect of unaccompanied children, but maybe we'll come back to that.
Fantastic. Listen, so, I mean, I think trying to cram all the problems into 5 minutes, you did a masterful job, Caroline. But can I say, for anyone who's interested, Article 39 have a brilliant website and they have really good resources and they have a fantastic Twitter feed. So we will come back to Caroline, but just to say, definitely go and look at the work there, because it really, provides further information on the key issues that Caroline's flagged there and that she does such important work on. I'm going to lean over to you, Leila. You need to press it to turn it on now. Next one. Actually, Joe.
Thank you so much, Anne, for such insight on the global, kind of like global status of children's rights, or lack of thereof, sadly. I think I'll be drawing my own perspective from my own lived experience and my life in detention, and what that means for children in, their formative years and of impressionable age. So in my case, I was placed in a detention center, and it was Hammersworth, as I know it, and it's the largest detention in all of Europe. And what I saw in detention was, absolute horror. There were solicitation and gangs and recruitment and, all of this. And detention, if we all know, it creates broken people, and what it does to children even further is especially jarring and harrowing. So yeah, and I was also a part of the May 8th Global Coalition on the Rights of Children, especially with, detention. And I'll be drawing upon 2 takeaways that, my suggestions. And so it was 1, to replace child immigration detention with community-based support, including access to services. And then 2, create economic, educational, and social opportunities for children and youth who were former detainees. From the perspective of an outsider, I have left detention, but the question is, have detention left me? So the impact of detention, it follows you through and through. And like I said, it creates delinquent, children and youth outside, detention. And to go further into my, insights, provide alternatives to detention. So government should establish effective community-based systems to provide a more humane way to manage migrant and asylum-seeking children and their families. Alternatives to detention could include accommodation for families, community-based support services, case management access, and obviously financial assistance. We have heard today, like many examples, like she said, and Caroline and Anne, of how intersectional these things are. So from detention, children go out, and the problems follow them through and through. And then second, strengthen safeguarding measures. So government must prioritize safeguarding measures for children throughout the immigration process. And by no means was I, a child going through all of that, but the impact on me, detention till this day, I still live with it. And obviously even more, disturbing that children have to go through these things under our watch. So yeah, alternatives to detention should include, this includes appointing independent guardians or advocates for each child, conducting regular welfare checks, and implementing child-friendly and trauma-informed procedures, adequate training for immigration officials on child protection services or issues, because my experience again in detention was the utter lack of safeguarding from the guards in detention. They couldn't care less. And again, what was especially peculiar for me in Hammondsworth was the fact that the detainees outnumber the guards 20-1. So it was just too much chaos going on in there. And if we've been following the news, just recently there was a riot in Hammondsworth, and I was like, that took long enough. So yeah, so it's all of this very dark reality of people like myself and children in detention. So I'll stop there for now. Thank you so much.
And may I say that in addition to being a safe passage young leader and doing incredible work around the position of children, young people who have experience of migration and the horrible conditions associated with it and the horrible framework associated with it in this country, that Joel, in addition, is the founder, member and volunteer of his own non-profit organisation, Mordi, the eBay Foundation, which is Nigeria's only charity catering for young LGBT+ students and vulnerable people to keep them in school, including young girls experiencing period poverty. And again, the website has fantastic resources, but Joel has spoken about one part of his important work today, and I would suggest over drinks that you corner him to hear about the other bit of his work, because it is equally exciting and deeply inspiring. Anyway, I'm now going to turn to our third speaker, Eulalie, who is based here at Doughty Street Chambers and who has extensive work, particularly related to mental capacity and mental health, equality and human rights law, and she is joint leader of Chambers' Court of Protection and Mental Health team.
I feel something of an imposter because I really don't know that much about children's rights, but I'm going to do my best. Perhaps the 5-minute guillotine is a good thing for me in particular. I was asked to talk a little bit about children and gender identity and I've chosen to focus certainly on the UK, and for these purposes, I was really, it dovetails or it confirms some of the things that you were saying, Anne, about this, what we see as a sort of nativist conservative move in relation to the behavior of states, governments, and indeed international institutions being peopled by those other institutions. Because in the context of the UK, when I looked at the issue of gender identity and the protection of autonomy in relation to children, transgender children and LGBT children as well, what we see here is not a resource-led problem, it's an ideologically driven problem. And I think that all I wanted to do in my time was to talk briefly about 3 sort of phenomena that I've noticed in this area, which is one, firstly, just to talk a little bit about Gaelic competence and some what's recently been going on in relation to that and puberty blockers. Secondly, to talk a little bit about the conversion therapy ban and the exclusion of trans children. And third, the EHRC's approach to the definition of sex as biological sex. And I don't really need a lot of time to do that, I don't think. And But immediately when you remind us that we should return to the convention, I think about certainly the concluding observations in relation to the UK talk about focusing on children's rights to identity, and certainly to develop there and enjoy freedom of expression. And what we've seen, certainly jurisprudentially, is a move in the courts to try and actually stymie that. And one of the cases was obviously is one that I mentioned briefly here, Bell and Tavistock, which was a case about puberty blockers, which you're aware. And I mean, in some ways, you can see quite clearly the conservative, the thread when you look at the High Court decision in Bell, because it talks about children at 13 and 14 possibly not being able to make decisions about, capacitated decisions about puberty blockers. And it strikes you when you read that there is no legal restriction on Gillick competence in any other area of medical intervention, to save for the forced sterilization of an 11-year-old in 2019. There's no other restriction, but suddenly there is an issue about gender realignment, and the courts start talking about restricting Gillick competence. And so that tells you about what I'm describing as an ideological drive. And then what is welcome in this department is the Court of Appeal reverses that and says, well, actually, there shouldn't be no restriction on Gillick competence. Puberty blockers are like any other medical intervention. You know what you're competent at, what you're competent at assessing. Capacity is decision specific, as it is in relation to all sorts of things. You don't have an age presumption in terms of capacity, and that's the whole point of Gillick. So that was reversed in the Court of Appeal, but what you also see at the same time is the things like the exclusion of trans children in the ban of conversion therapy. And I mean, the argument about the conversion therapy ban is that, you know, it would make it difficult for parents, for example, to have discussions with their children about the process and their views on, for example, gender realignment or puberty blockers or hormone therapy. But I mean, the thing is, again, you can't escape the impulse, because of course you can deal with that by actually having guidance on what isn't covered by the ban. And the irony is you encourage a situation where, I mean, you can, excluding things like corrective rape and the more serious things. Sorry, I didn't mean to imply that there's a lower level of conversion, but I mean the ones that are obvious and extreme. But if you don't have any ban in relation to trans children, then you have a situation, for example, where one parent can advocate pseudoscientific counseling or something, and the other parent can object to it, for example. And the child, unless the child is Gillick competent, the child's in a terrible situation. So that's the other issue. And finally, the last thing I was going to say about this is that children, in some senses, are a staging post in what I think is this conservative ideology around gender identity. And in fact, they're obviously the most important staging post, because that's where the issue is going to first arise. And I wanted to say that this whole obsession, we see it manifesting in the children's rights discourse, this whole obsession with immutability in terms of sex, etc., is where that's what's driving the phenomenon here. And I think that for me, from my, certainly, if you're Black, you know that immutability is nonsense. And also if you're gay, you know that the reasons why you're gay are nonsense. So I think that there is a way in which that is part of what we perhaps can do to respond to your call to actually look for remedies and think about the ways around some of these problems that are developing. I think that's all I've got time for.
Thanks very much. And I very much appreciate the combination of highlighting the problems, but also thinking through the solutions, which have been a very strong part of what panel members have said. I'm going to turn over to Xu Xin, who is co-lead of the Children's Rights Group and who does practice in public law, but has a really strong human rights, civil liberties and anti-discrimination focus. So.
I was just going to pick up on some of the things that the panelists and Anne have said. I mean, the starting point when I was thinking about this is, children's rights don't erode overnight. They don't fall back overnight. They don't push back overnight. And why do they? I think it's because policy and lawmaking have sort of tended not to treat what children need, what children want, how children behave as something distinct from what an adult needs and how an adult behaves and what an adult wants. And one way is, as you highlighted, Anne, is that children's interests and rights are often subsumed into the family unit. So it's quite interesting when you were talking about Article 5, I went back and looked at Article 3, because Article 3.1 says, in all action, you have to treat the best interests of the child as a primary consideration. It acknowledges in Article 3.2 that it takes account, that principle takes account of the duties and rights of parents and carers and what they have to do for children. So but irrespective of that, and in addition to that, there's still this ultimate overarching responsibility of the state to treat children as rights holders and children's best interests as not a trump card, but a primary consideration. And the selection of primary, I think, is important. But when you look at the UK, and I'm going to be the end doomsayer, sorry, but you look at the UK, and particularly in the state of socioeconomic rights, you can see that children aren't rights holders. They are subsumed in family policy making and subsumed in what their parents' duties and rights are. And when you talk about the serious regression in child poverty, the UK is a prime example of that. One of the wealthiest countries in the world, but you've got a benefit cap that has been frozen since 2013. I mean, it even lowered in 2016. And if it's not uprated for cost of living, 120,000 households are going to be affected, including 300,000 children. You've got a 2-child limit cap to child costs for universal credit, which, although valiantly trying to be challenged by the Child Poverty Action Group, was unsuccessful. And what it does is it breaks the link between benefits and the right to social security, linking that to children's needs. And it doesn't think about the increased risks of poverty for larger families. And the statistic lately is that it affects 1.3 million children, and it's about to double this year. And what's interesting is what the Supreme Court said in upholding the 2-child limit. It says, well, who is to question Parliament for the balance to be struck between the interests of children and parents receiving support from the state on the one hand, and the interests of the community as a whole, and placing responsibility of caring for children into the hands of their parents. So it is precisely that kind of tension between children as right holder and do children have rights independent of their family unit. The government's answer, which has been accepted by the court, is that parents should just work and work harder. I would just simply say that's just fake news. Because 75% of children in poverty live with families where there's one working parent. 32% of parents with preschool aged children spend more than a third of their income on childcare. So that is not going to be the solution. So that's one way. A second way in which there's been erosion in the UK is something that Carolyn has sort of mentioned at the end, and you've also picked up on migration. And in terms of the illegal migration bill, and maybe that's a way to end the depression, is there 3 key ways where it fundamentally blows a hole in any child protection that we have in the UK. One is you can now, if it's passed, and it will be passed in some form or another, there's a power to remove a child presumptive refugee to another country without even looking at the safety issues and protection issues of that child. And even if the Secretary of State doesn't decide to remove at the time they're a child, as soon as they turn 18, they can be put on a plane to Rwanda or insert country here. Secondly, is the detention of children. If there's one thing that the Home Office has done over the years that is good, and please don't ever quote me on that again, is that they have constrained the bases upon which children can be detained, and impose time limits, and impose very strict conditions on when they can be, how they can be. And that's going to be gone. And the third thing, finally, is something picking up on what Carolyn said, is that slippage into a 2-tier, 3-tier, possibly multi-tier system of care, where your care is determined by your migration status as well as your age. And you will know the hotels are being used outside the care system, but even when they don't use hotels, they're using reception centres as temporary housing, roof overhead with a social worker, that's called care, until they get transferred to another local authority. So these are another three main ways in which children who don't have families have their rights eroded in the UK.
Okay, thank you so much for that. And I think it'll be interesting if Caroline, has additional things to come in there, but certainly I know there'll be shared views. There'll be high levels of agreement between you. I'm now going to turn over and do questions. And the way I propose to do this is, first of all, to say we're going to take an extra 5 minutes because we started 5 minutes late. Let that be a lesson to you all to get here on time the next time. There's always punishment. But also I'm conscious that we have 50 people online, so we're going to take a chunk of questions. Can I ask people who are online, in fact, I think we have 55 people online, can you please put your questions in the Q&A, because it's more straightforward that way. However, Anne, can I ask you to join us? And you might actually want a glass of water at this point. And what I'll do is I'll start by doing a round in the room. And can I say, I know that many of us here know each other, but Anne is going to know hardly anyone. So if people could just introduce themselves briefly. And could I also ask, could we try to keep questions as, or comments relatively short, just so we can maximize input. So let me just see, are there any immediate questions? Right. I'm going to take them in 3. Okay, so the gentleman there, please. Yeah.
Hello.
Pen.
Sorry, I'm not asking question, it's just a comment. To add to what Shu just said, I think what I've realized from my experience, meanwhile, it just, before I came to UK.
Sorry, can you introduce yourself?
Okay, my name is Chinonso Ijezie. Before I came to UK for 4 years, I used to do litigation work for International Federation of Women Lawyers, Lagos State Branch, or FIDA, or what they call Federación Internacional de Abogados. So they protect women and children. So I did work for them. And to offer solution comment as to the Article 5, you said, I think Sue just offered the solution, but it wasn't firmly put. Is to focus attention on Article 3.1. And that is what I was doing. Modi might explain, understand what I'm saying. Back home is quite difficult. So what I was doing then, is that if you go to court, emphasize the language, best interest of the child, best interest of the child. But the problem here in the UK, when I came over here, is that I realized that language is not used often in the court. They use welfare of the child. And for me personally, I decided, since they're using welfare of the child, I use welfare best interest of the child. I think my suggestion is that for practitioners here, if we could emphasize that word, the best interest of the child, you see what it has is that it addresses the issue of over-focus on Article 5 and also addresses the problem that Caroline was saying. Thank you very much.
Thank you so much. That was wonderful. I'm sorry for cutting you off. It's simply because I can see other hands, but it's a very interesting point, and I'm sure speakers will respond. Francesca at the back, I think you had your hand up.
Thank you. I better stand up. We won't see me, Anne.
And do say who you are.
I'm Francesca Clark from the LSE. Thank you for a fantastic lecture, and the whole panel. Really grateful for your really interesting contributions. And I just wanted to say that I really found your argument very compelling about the pushbacks against the extraordinary document. I agree with you. It stood the test of time, the International Convention on the Rights of the Child. And I'm sure you've got your own pet theory as to why these pushbacks are happening. And I'm sure that we all have in this room. So I kind of wanted to ask a question that turned that on its head. And I'd like to know your reflections on what were the forces that existed in our world in 1989, and even going back 40 years before that, when the Extraordinary Universal Declaration of Human Rights was drafted, albeit it it is a document of its time. What were the forces that allowed those incredible instruments to be drafted and agreed around the world that we are lacking now? Perhaps that will help us think about where we need to go. Thank you.
Wonderful. Thank you so much, Francesca. Will I take a third question in the room? Okay, no, I'll take one from online. So this is from Colin Rafter, and Colin Rafter, who I think you know, Anne, used to be based in South Africa. He works for the Irish Department of Foreign Affairs and used to run the Human Rights Unit there, has asked, thank you for your stimulating address. Which actors outside the UN system, if any, are well placed to provide leadership and guidance in the battle to promote and reverse the pushback against children's rights? And I know you dealt with that to some degree at the end of your talk, but you may want to refine that further. There's also one other question online, which is from Dan Gibney. Thank you for your fascinating talks. I'd love to know your thoughts about the role of age assessments in asylum-seeking children and how to make progress on this. And I'm not sure if you want to engage with that, but I'm sure that there will be others. In fact, probably the whole rest of the panel wishes to engage with that. So thanks. Let me hand over to you, Anne, and then we'll do a round, and then I'll do a round of everyone here.
Thanks very much for your comment. I mean, I do think that, you know, best interest is another one of these concepts which is very useful, very flexible, and has been powerfully used, but can also be abused. So it's another one, like Article 5, unfortunately, where we run the risk sometimes that children's rights always have to be viewed through the prism of best interests. And I think that creates a risk that somehow children's rights are not quite accessible to children in the way that adults' rights are accessible to them. So whilst we cannot do without best interests. I cannot imagine lawyering without best interests. So it just blows my mind. but at the same time, I think we have to be wary of it, because some states will say, yes, we are dealing with the best, we operate on the basis of the best interests of the child, and we know what's best. And, you know, families, after all, have the best interests of their children at heart, you know. So these are, you know, it opens another interesting conundrum. Francesca, what existed, it's quite interesting if you look at the drafting history, particularly of the 1959 declaration, a big factor was the involvement of the communist states in the drafting. And it was a positive factor, because that's how socioeconomic rights got into the convention, in the sense that, you know, there was a big push for education to go in, and there was, you know, a lot of dialogue about that at the time. But by 1989, I would say that was definitely no longer a factor. But there was a strong, not at the beginning, Poland brought the application, they did the first draft and presented it, but apparently the first draft was very weak, pretty much like the declaration. And then states started to seriously sit around and have a look at it. And UNICEF was also very weak at the beginning, but got stronger as time went on. And there was a very strong NGO coalition that attended, and it took quite a long time. It was a 10-year process of drafting the Convention on the Rights of the Child. The chairperson was Polish, and I think he worked very much on a consensus building system. So he made sure that the states would buy in. So by the time the Convention on the Rights of the Child was finished, the debates had been had by at least those states that were in the room. Of course, we must remember there were a lot of states that weren't in the room. But I think that is part of the reason why it was relatively easy to get buy-in and follow-up afterwards. I also think that UNICEF, although they came a bit late to the party in terms of, you know, recognizing rights, did do a lot of work on the ground at the national level in encouraging states to ratify and preparing states for that ratification and reporting process. And that might be something that other conventions don't have quite the same, a UN agency so dedicated to rights of children. So those might be some of the factors, I think, that were at play. Colin's question, which actors outside are well placed? Well, I think, you know, civil society still plays a massively important role, because even in the Human Rights Council and the General Assembly, which are state-driven processes, there is a lot of engagement with civil society actors, and at the treaty bodies like the Committee on the Rights of the Child, we would not be able to do our work without civil society input, and UN agencies, and NHRIs, Children's Rights Commissioners, all of these people whose information we consider to be, especially NHRIs and UNICEF and other UN agencies, we see that information as being balanced, reliable, and so on. NGOs we see as being often high quality, specialized inputs. You know, obviously NGOs have their agendas. That's clear. The agendas have to be factored in. We can see them. We know what they are. But I think these civil society actors are hugely important. But also the role of the progressive states is important. So in other words, those states that do still believe in human rights and children's rights have got their work cut out in keeping on going and, you know, fighting the fight. And I think we can also, in a way, as civil society, form alliances with them as well. Well, age assessment, the only thing I will say about it is that the Committee on the Rights of the Child has dealt comprehensively with age assessment under its communications procedure. We've had many cases about this from Spain, against Spain, and we have made it clear what we think about this, which is basically that there's an over-reliance on medical testing, which is unreliable with a huge margin of error, and therefore that it's necessary to give the young person the benefit of the doubt if it's unclear, because it's impossible from those tests to determine exactly whether the person is or isn't a child. And that we should rather use more multifaceted approaches to assessing age, and that we must accept any documents that children present as being genuine. And you know, there's a lot of states that will say if it's not biometric information, we won't accept it, which is really very unreasonable. And again, until some documentary evidence is brought that counters the documentation that is presented by a child, that documentation should be accepted. So that's the committee's position on age assessment.
Thanks so much, Anne. There's one final question that I'm going to ask you before we speak. I can see that there's a comment from our colleague Geraldine Van Buren, who was involved in the drafting of the UNCRC, I think on behalf of UNICEF, but I may have that wrong. But her comment is, the 1980s were not so different from now. We encountered a great deal of opposition, so strategically we decided to go around the governmental opposition and engage grassroots directly. This now is usually with social media. Perhaps there's been too much of an emphasis on persuading governments and less working with grassroots. Certainly, I find a great lack of awareness of the CRC provisions when one goes outside of NGOs. So thanks so much for that, Geraldine.
So Geraldine could have answered your question.
Yeah, absolutely. And I think she has supplemented and complemented your answer in a technical term. But absolutely, and it's wonderful to have her input there. I'm going to ask you one last question, and then this is the final question because I don't see others in the room. And so, there are two others. Well, that's fine. Actually, then what I'm going to do is I'm going to take 3 questions, and then I'm going to give the panelists to have a go, whichever questions you want to the whole group. So this one is, sorry, gang, grab your pen. This is from Roisin Webb, who's a superb children's rights lawyer in Ireland. There's a lot of Irish on today, I note. Myself and Keelan smugly grin to each other. All our cousins are online tonight, but she says a very interesting discussion with regards to Article 5. I agree that the best interest principle is also misunderstood and often used in a paternalistic way. Then she goes on to ask, is the communications procedure creating a body of more specific application of these concepts in a way that might help promote an interpretation that interprets children as more visible individual rights holders, both within the family and independently? So, straight direct question, what is the committee doing in this context? What opportunities does it have and what efforts is it making? I'm sorry, I see the 2 people who I was just completely ignoring. Javed, can you introduce yourself? Do you mind? Yeah.
Yes, certainly. My name is Jawed Lukmani. I'm a solicitor at Lukmani Thompson Partners. It was just following on from the earlier debate about the idea of the best interests and the idea of that subsuming within the family, perhaps because of a very conservative approach to the concept of family and children being seen but not heard. And I wonder whether we should all be promoting the idea of best own interests so that there is this independence for the child so that it doesn't become subsumed within the family.
Okay, wonderful, thank you. And I think the gentleman behind you as well.
Sorry, I was also going to ask for your recipe for chicken soup.
That's very good, Jared. She'll tell you about that over drink, absolutely.
Hey, my name's Ben. I work at Duncan Lewis. I kind of had a question in the context of the discussions around the illegal migration bill, and just thinking about also the Nationality and Borders Act and the provisions on trafficking. And to me, it seems to affect some of the most vulnerable children in the system, let's say victims of forced criminality. And how do we really best vindicate the rights of children that have gone through experiences of trafficking as children when there is such obvious attacks domestically to their rights in present day?
Fantastic, thank you so much for that. Now I'm going to turn to Anne. There's one final question just quickly, because I'm conscious that we have a question from a colleague who's an East London GP who asks about challenging the move to online GP access, which results in the disadvantaging of young people. I'm actually going to leave that question because I don't think it's one Anne can engage on, but if the other speakers wish to have a go at it, absolutely. But listen, Anne, I'm going to pass to you, and then I'm going to pass over to the panel.
Okay. So the first question was about whether under this optional protocol on a communications procedure, and just for those of you who are not very familiar with it, because the UK hasn't ratified it yet, is that it is a complaints procedure, basically, under which individuals or groups of children can bring complaints against the state, but the state has to have ratified the convention for them to be able to bring it. And the question that was posed is, well, what is the committee doing to make sure that rights are articulated in a clearer way? What I have noticed is that our work under the communications procedure is very different from our work under in the reviewing of states parties, because when we review states parties, we can afford to be very expansive in the way, you know, states should do this and should do that, and we recommend and we strongly suggest and we urge the state to, you know, and we argue for hours about which word to use. But that is very generic. But when it comes to finding a violation of a right, then you do have to be quite specific, and you actually have to tie back again to the actual wording of the convention, because you have to think about to what extent you can find violations of things that have been expanded massively in the general comments, because states will, you know, not be very comfortable with that happening, although I think the committee is certainly able to interpret the rights using its own previous interpretations, and we do. Personally, I think it is very easy to overuse Article 3 because almost every rights violation, the author of the communication will cite Article 3 amongst many others. But if you look at our jurisprudence, sometimes we will say we find a violation of Article 3 read with Article 37B, and that might be about detention of children in a particular context and the fact that children's best interests were not considered when making the decision about that deprivation of liberty. So if you can see what I mean, not just saying yes in every case where children's rights are violated, there's an Article 3 violation, but actually trying to balance what is it. So in migration cases, for example, there's often quite an absence of a consideration of best interests of the child, and that's a procedural violation. So this is the other thing, is that Article 3 has different ways of being used, and one of them is a procedural way. And if we can, and it's very easy when we can see that the best interests of the child wasn't considered at the national level, well then clearly there's a violation of Article 3 because there was no consideration of the best interests. If we can see that there was a consideration of best interests, it becomes a little bit more difficult as to whether the committee can supplant its own interpretation of what is in the best interest of the child with a court's interpretation of that, because we're not a court, we're not a fourth court. So generally speaking, I would say most of our violations of Article 3 are about the procedural element of Article 3, where we would find a violation if the state had been shown not to have considered the best interests of the child. Your question about, so how do we get around this problem of best interest? I mean, what I say about it is, look, let's just go back to rights. Let's just say children have rights, and then we are more able to argue for them. But that's not to say that I don't think best interest has its use. I think that we need best interests, and particularly when there are other weighing interests, and then what you want to focus on actually is it's the child's best interests and not this parent's best interests, or that's where it's really useful and powerful. But I think when we are actually looking at upholding children's rights, let's just go straight for the right rather than the interests. I'll leave it there.
Thank you so much, Anne. Right, I'm now going to turn and give everyone a chance to take the next 5 minutes. Everyone, but just come back in, because there's a range of different questions, you have a range of different experiences and thoughts on it. So please, I'm actually going to weirdly start from the person to the left, because it's finished with Joe. So Shushin, do you have any thoughts on any of the questions? You may not do.
No.
Great, fair enough.
Yeah, and of course I won't answer them all, but I'm not going to. Article 3, the Committee on the Rights of the Child's general comment on best interests loudly and strongly affirms that you cannot come to a judgment of a child's best interests without knowing the child and honouring their right to be heard and to have due weight given to their own wishes, feelings and views. And actually, if you look at the history of the drafting of the convention, at the beginning, Article 12 text was in Article 3. It could have, if it had stayed that way, ended up that we'd had a best interest that recognised the child as a human being. Second point, I'm only making 3 points, is the UN Committee's communications procedure. One of the best features of that, I believe, is that actors can act on behalf of the child. So NGOs can use that procedure on behalf of babies, on trafficked children, on children in care, on children who are in prison and too terrified to raise their voices and are not safe to assert and claim their rights. And if we ever get, Francesca, forgive me for saying this, but if we ever get into a safe environment where we can look at how could our own Human Rights Act be improved for children, we'd want a provision in there where NGOs can act for children. Finally, on the forces in 1989, when the UN adopted the convention, of course, you have to go back to the late 70s when it was proposed and what was happening in the late 70s and before. All of the groups of human beings in the world that had hitherto been seen as and told that they were not human beings had won. There had been successive fights that we are human, treat us as human, respect us as human. And of course, children were part of that. And that's, I would say, even before you say children have rights, you say children are people and human beings.
Fantastic, absolutely. Really fantastic. Thank you, Caroline. Eulalie, do you want to come in on anything? You don't? Okay. Joel, do you have any thoughts you'd like to come in on?
I think when it comes to the rights of, children to right information, we're seeing erasure of education, inclusive education, when it comes to LGBT plus, materials. And that kind of like brings Section 28, which the entire premise of Section 28 at the time was erasure. So I, as a young person or someone in school, my existence is being erased from, discourses as important as education. So we're seeing that making a comeback, like you stated. And it's not only the UK, it's around, the world. And we're not even talking about countries where LGBT rights is non-existent. And we've seen this thing firsthand happening in classroom where bullying is the order of the day and, all of that. So yeah, I think we should, by all means, profess solutions and fight back. Now is not the time to second guess our collective and individual strengths, so yeah, I think that's, my take.
Okay, well, listen, I know we all, we've lots to think about and chat about as we move to the more relaxed part of the evening. But before we do, I just want to very quickly do some thank yous. I want to say thank you to Ryan and Camila, who made this evening possible, and Cynthia and Sian, who were also fantastic. And of course, Shushin to my left, who both spoke and co-organized it. I'd like to thank our children's rights group members who do such important work in relation to children's rights, and to all of you for coming at what we know is such a busy time of year. I want to, before I thank Anne though, I want to say, and she's not in the room, but I do want to say a special thanks to and pay tribute to Emily, without whom the children's rights group just wouldn't happen, because she chases us, she organises us, and then she makes sure we turn up. But she's just been amazing, and she's off to have another an exciting new adventure, but she's just fabulous. So thank you, Emily. And finally, can I ask you to join me in thanking our wonderful panel and our fabulous speaker. Thank you.